All right, welcome back. This is part two of chapter four on attempt crimes. And we left off on conspiracy. And I just want to go over just one more time because this can be a little bit confusing when you're actually reading the facts. And that is when a co conspirator is criminally liable for the foreseeable acts of other co conspirators. Again, don't throw out common sense. A co-conspirator is going to be liable for the criminal acts of others involved in the conspiracy if the additional crimes that are committed are foreseeable, meaning they don't have to agree upon it. They don't have to anticipate in the sense of talking about it prior to the conspiracy. If the end result is additional crimes are committed, and those are additional crimes were committed uh, during the conspiracy, as part of the conspiracy, everyone involved in the conspiracy is going to be criminally liable. All right, so now we're going to move on to um, this. This is a one slide. It's not part of the exam, but I include this so that you have a kind of an understanding of how conspiracy can play out in a courtroom. So, People versus Aranda is a case where you had two co-conspirators. The issue was one of the co-conspirators was willing and made a statement to law enforcement, and the other co-conspirator refused to make a statement to law enforcement. When that happens, it creates a conflict for each conspirator. So if both are being charged and one has made a full confession or has made statements and the other has not, it creates a challenge for prosecutors. For instance, a few years ago, there was a murder where you had a husband and wife that were getting a divorce. The wife had decided to kill her husband, and she recruited a friend to help her with the murder. The friend and the wife go to the ex husband's house, kidnap him, kill him, and then during the investigation, law enforcement determines that the wife and this friend are the ones that did the crime. When they interviewed the friend chose to talk to law enforcement, gave a full confession, explained exactly what they did, how they did it, the details, the tools they used, time, everything. The wife asserted her Fifth Amendment right to remain silent, said nothing to law enforcement. So during the trial, prosecutors had to decide how they were going to handle this. If you if you pursue or prosecute both individuals in the same courtroom with the same jury, here's the conflict. The individual, the friend, who made a full confession to law enforcement, it was a lawful confession. The prosecutor has a right to use that statement in court by placing the officer on the stand and asking the officer to repeat what the individual said. So you have a full confession. Problem is, the wife, who said nothing, who is also being prosecuted in the same case, would have a right to cross-examine the friend. But the friend has a right to remain silent and chooses not to testify at trial. So the wife's right to cross-examine the person who made the statement is being violated. So the way prosecutors usually handle something like this, depending on the case, they are put in a position where they have to have two separate trials. They would prosecute the wife separately, and they would prosecute the friend separately. In this case, what actually happened was the prosecutor prosecuted the friend first, separate trial, separate jury, and the prosecutor was able to introduce all of the statements against the friend because the friend had made a full confession, and those statements were allowed to come in front of the jury, and the jury was able to hear the statement. Once they completed that trial, this person was convicted. Then the same prosecutor prosecuted the wife. And again, during that trial, separate jury, The prosecutor was not allowed to use any of the statements that the friend had made, and so the prosecutor had to rely on other evidence in order to convict the wife. So that's one of the issues or challenges that are created during a conspiracy if two people are charged with conspiracy. All right. So now we have conspiracy, we have attempts, we have solicitation. And these are a couple of defenses that pair up with attempts and with conspiracy. The first one is abandonment as a defense. What if you decide to pursue a crime, and at that point in time, when you are now in the execution of the crime, you determine that you don't want to go forward? Can you use that as a defense? The general answer to that question is yes. You can use abandonment as a defense. The defense of abandonment generally connects with attempt crimes. Here's the rules. If you're going to use abandonment as a defense, you, the defendant, the burden is on the defendant. You must show that the decision to abandon the crime was free and voluntary, meaning it was not prompted by any outside influences. What does that mean? That means that the decision to walk away has to be on the defendant, their own decision. There cannot be anything else that would influence or in any way would affect their opinion of whether they should go forward. So, for instance, if you have an individual who decides to rob a liquor store, and they have, let's assume they're going to use a gun. They have a gun, they have a getaway car. They pull up into the parking lot of the liquor store. They start to get out of the car, or they get out of the car, and they walk into the liquor store. And as they walk into the liquor store, they realize that there's a police officer at the counter buying something from the cashier. If at that point the defendant decides to abandon the crime, in other words, at that point they walk away, turn around, they walk out the door, they go into their car, they drive away. Question is, can they use abandonment as a defense if they were to be later arrested? And under those facts, the answer is no, because they were influenced by the fact that the officer was present. That officer being present is an outside influence. If the individual had walked into the liquor store and realized there was 5 people, customers inside the store, and at that point in time they got cold feet and said, nah, I don't want to do this because there's too many people in the store, and they walk out, the fact that there were 5 people in the liquor store, that's an outside influence, and they cannot use the defense. They cannot use the defense of abandonment. So when can you use it? So if you were same set of facts, individual walks up to the liquor store or drives up to the liquor store, steps out of the vehicle, has the gun ready to go, walks up to the liquor store, and then starts to realize that they are too scared, or that they have time to reflect and realize that if they do get caught, they may go to jail, and that's a deterrent for them. Or they may walk up and say, you know what, I have a family, I have children. If I get arrested, it'll ruin my family. So I choose to walk away. That's free and voluntary. So it can't be anything else. So let me give you another example. You decide to burglarize a house. So you walk up to the house that you've decided to burglarize, and you again say to yourself, well, if I get caught, I'm going to go to jail, and I don't want to go to jail, and the person walks away. That's free and voluntary. You could use the defense of abandonment if at that point you were arrested by law enforcement and charged with the crime of attempted burglary. Let's assume same facts, but we're going to change a couple of facts. You identify a house that you want to burglarize, but you want to make sure no one's inside the home, so you don't, so nobody can ID you, or that you're not going to be confronted by anybody. So you decide to knock on the front door, and you knock on the front door, thinking that no one's going to answer. It'll confirm your suspicion that no one's home, and then you'll proceed to the back of the house and do the burglary. In that case, when you walk up to the front door and you knock on the door and somebody answers and you just look at them and you pause for a second and you say, "Hi, is Bob here?" And the owner of the home says, "No, but there's no, Bob doesn't live here." And you say, "Thank you very much," and you walk away. So you abandon the idea of committing a burglary. You cannot use the defense of abandonment because the fact that somebody was at the home and answered the door is an outside influence, and therefore you cannot use it as a defense. Okay, so you have abandonment. It's usually connected to attempt crimes. Is there a defense for conspiracy? What if you have co-conspirators that choose not to continue participating in the conspiracy? There is a defense of withdrawal. One can withdraw from a crime. Certain things have to happen. You have to address your co-conspirators. You don't have to address all of them, but you have to address at least one. So if there's 3 co-conspirators, one of them decides they don't want to participate, they have to communicate that to another co-conspirator. And then they have to do some act, some overt act to make a clear withdrawal. They either need to walk away, return items, do something to say, "I'm no longer involved." And here's a distinction. If you text your co-conspirator, you've been invited to participate in conspiracy, and you say, "Yep, I'm in," and then the next day you say, "You know what? That's not a good idea. I'm going to change my mind," and you text your co-conspirator and say, "I'm not in, and by the way, you can't use my car, and I'm not participating." That would be enough. You've withdrawn the car, which is an overt act, and you've communicated to a co-conspirator. You could then, if the other co-conspirators go through with the conspiracy and you're implicated, you could use a defense of withdrawal. But you have to communicate to your co-conspirators and you have to do some overt act showing that you make a clear withdrawal. The distinction is this. Let's say you get invited to engage in a conspiracy, you agreed to the conspiracy, and on the day of the scheduled conspiracy, you just don't show up. That's your way of withdrawing. You're saying, "Well, I'm just not going to show up, and therefore I'm no longer involved." You cannot, again, I say you cannot use the defense of withdrawal because you never communicated to co-conspirators. Even though you didn't show up, you never said anything. So if those co-conspirators now go and complete the crime, and they're now being charged and arrested for a completed crime, you could be charged with conspiracy and you could be charged with the underlying crime because you never withdrew. So you cannot use that defense. So let me just repeat it one more time. If you just simply do not show up on the day of the conspiracy, you just choose not to participate, that is not enough to use the defense of withdrawal. You have to communicate it to one of the other co-conspirators, and you have to do some act to show that you are out. So it may be you were supposed to do something for the conspiracy, and you choose and you do not do that thing, or let's say you're the one that provides certain tools in order to go forward with the conspiracy, and now you simply take those tools back, and you communicate to your co-conspirator saying, "I'm not involved, I'm out." Then you are no longer liable for the conspiracy. And where this plays a huge role is that if you do engage in a conspiracy and then you do a proper withdrawal and something goes wrong during the execution of your conspiracy, you're not going to be liable for the conspiracy or any of those foreseeable crimes that are committed. And that's the key. That's the big thing with withdrawal. Any foreseeable crimes, you are going to be off the hook. All right, this ends part 2 of chapter 4, and your next job is to go to part 3, and you're going to have an assignment in part 3 that you'll need to complete. So be safe, take care, and look for part 3 of chapter 4 on attempts. Thank you. And we're done.